Good evening, everyone. There we go. Nice. Thank you. Thank you. I want to welcome everybody to NYU Law. My name is Vincent Sutherland. I'm the faculty director for the Center on Race and Equality in the Law, which, in partnership with the Peter L. Zimross Center on the Administration of Criminal Law, serves as the institutional home for the Kenneth P. Thompson Lecture on Race and Criminal Justice Reform. Tonight, I am standing in for Dean Troy McKenzie of the law school, who unfortunately had to be called away and was not able to make it tonight, but did want to extend his thanks and welcome to all of you for being here. And it's my real privilege to welcome you tonight for tonight's lecture. This lecture series is one of the most meaningful events that we host each year. It provides an opportunity to engage in the difficult but necessary conversations about race, power, and the criminal legal system. Conversations that Ken Thompson dedicated his life to advancing. The distinguished guests that we have tonight have been leaders in pushing for a justice system that is not only fair, but also accountable. NYU Law is honored to be the home of this lecture series. Ken Thompson was a visionary leader and a devoted public servant, and this lecture is a way for us to carry forward his commitment to justice. Ken made history as Brooklyn's first Black district attorney, a role in which he championed criminal justice reform and worked to correct wrongful convictions. But his dedication to justice was evident long before he took public office. As a student here at NYU Law, he was awarded the Arthur T. Vanderbilt Medal, the highest honor given to a graduating student for service to the law school community. And in Brooklyn, Ken's office took bold steps to right past wrongs, created one of the most renowned conviction review units in the country, helping exonerate dozens of wrongfully convicted individuals. His work reminded us that the pursuit of justice must extend beyond convictions and sentencing. It must include reflection, correction, and accountability. This lecture series is a part of that ongoing work. It ensures that Ken's legacy is not just remembered, but actively carried forward. Before we begin, I want to take a moment to recognize someone without whom this lecture series would not be possible, LaShawn Thompson, Ken's widow. LaShawn's dedication to preserving Ken's legacy has been extraordinary. Her support, both through her advocacy and her generosity, ensured the creation of the Ken Thompson Social Justice Fund, and I encourage you all to support our efforts to continue this lecture series forward. I also want to acknowledge the Zimross Center on the Administration of Criminal Law and the center that I'm the faculty director for, the Center on Race and Equality in the Law, and the leadership of both centers, the students, and all the other folks who work at both centers, my colleagues Rachel Barkow, Courtney Oliva, and Jason Williamson, who are the leadership of those centers, for their role in making this evening possible, as well as Sue Anderson and the team at the Office of Development and Alumni Relations. Our conversation tonight will feature Professor Nicole Smith-Futrell, Susan Friedman, and Courtney Kai Oliva. I'm going to introduce them all right now. But before I do that, I'm going to say that these two will sit in conversation, Nicole and Susan, of course, will sit in conversation to discuss the real-world impact of prosecutorial misconduct, the structural changes needed to address these failures, and the path forward for ensuring a fair and more just legal system. Tonight's lecture is particularly touching for me because it comes on the 8th anniversary of the Center on Race and Equality in Law's launch, which happened in February 27, 2017. We were at the dawn of a new administration facing a new set of challenges, and we once again find ourselves facing outsized challenges today, with the last couple weeks of drama concerning the city's mayor and prosecutors, past and present, making this evening's conversation that much more prescient and important. And that conversation about prosecutorial accountability is especially important because we're talking about the accountability and duty that all in the legal profession owe the public, which is so critically important overall. So with that, it's now my pleasure to introduce tonight's panel of three dynamic and phenomenal women. I'll start with our moderator, Courtney Oliva. Courtney is the executive director of the Zimross Center. In that capacity, she has worked with organizations dedicated to criminal legal reform, including prosecutor reform groups, on issues relating to conviction integrity units, sentencing reform, executive clemency, mental health reforms, prosecutorial culture change. She recently served as a member of the Justice 2020 Committee for Brooklyn District Attorney Eric Gonzalez, Mr. Thompson's successor, and has co-taught a seminar on criminal legal reform in the District Attorney's Office. Courtney has experience as both a federal and state prosecutor and investigated a variety of federal and state crimes, but beyond that, as the only prosecutor on the stage, is uniquely positioned to serve as our guide through the world of prosecutorial ethics and accountability. So thank you, Courtney. I know you're laughing, but it's true. Susan Friedman, who's sitting in the middle, is the inaugural administrator of the New York State Commission on Prosecutorial Conduct, a new administrative agency that is dedicated to investigating prosecutorial conduct in New York State, serving to strengthen oversight of New York's prosecutors and to hold them to the highest ethical standards in the exercise of their duties. As the Commission's first administrator, Ms. Friedman is responsible for launching the Commission's operations and is also responsible for overseeing the day-to-day operations of the Commission, including oversight of the investigative processes. Prior to taking on this role, Susan was a senior staff attorney at the Innocence Project, where she handled all manner of post-conviction litigation and was lead or co-counsel in cases that overturned 10 wrongful convictions. And finally, least but certainly not last, Nicole Smith-Futrell, seated on the end, is a professor of law and co-director of the Defenders Clinic, and director of the Center for Diversity in the Legal Profession, and faculty director of the W. Haywood Burns Chair of Human Rights and Civil Rights Program. So a lot of jobs. Her career has been dedicated to advocating for the rights of those accused of criminal offenses. In her clinical practice, she and her students represent clients in a variety of criminal defense-related contexts, including state court misdemeanor cases, parole and clemency petitions, wrongful conviction matters, and civil claims related to criminal convictions. Professor Smith-Futrell's teaching and pathbreaking scholarship focus on criminal procedure, legal ethics, post-conviction relief, reentry, and social justice lawyering. Prior to joining the faculty, Professor Smith-Futrell was a public defender in the criminal defense practice of the Bronx Defenders, where I also was starting out as a public defender, and I see other people in the audience as well who may have some familiarity with that office. Contributing, where she and I were colleagues, Nicole was a leading light in that office, contributing to her immense talents, deep intellect, and passion for justice to the foundation of what is today one of the country's leading public defender offices. At BXD, she litigated misdemeanor and felony cases and conducted criminal law training for new attorneys and local community groups. And for purposes of tonight's panel, she, along with 5 other law professors, took the bold step of filing grievance complaints against current and former Queens prosecutors for prosecutorial misconduct, creating a website to collect and publish their complaints. I suspect we'll hear more about that during tonight's conversation. So join me in welcoming this phenomenal panel, and I look forward to the conversation.
Thank you, Vincent, for that introduction, and congratulations again on the Center's 8th anniversary. So I'm really excited to have a conversation tonight to highlight the important work that Susan and Nicole, through their institutional capacities, are doing to improve prosecutorial accountability in New York. Before we get started, though, I sort of want to frame this discussion for the audience, because I'm not sure how many of you are familiar with prosecutors and, sort of the power that they have in the legal system. I know some, but not all of you are. So first, right, prosecutors have a ton of power and discretion in the criminal legal system. Their charging and plea bargaining decisions influence everything from start to finish, pretrial detention to the likely sentence that someone will receive. Second, when they don't play by the rules, people suffer. A 2020 report on wrongful convictions by the National Registry of Exonerations found that prosecutors committed misconduct in about 30% of wrongful convictions, and that rate of misconduct was higher in cases that were much more serious and with higher stakes, like murder cases. And third, prosecutorial misconduct is not felt equally by everyone. The criminal legal system's race disparities are also reflected in prosecutorial misconduct cases. The 2020 NRE study that I just cited found that innocent African Americans were 7 times more likely to be wrongfully convicted than their white counterparts. And this disparity held firm across all major categories of crime except for white-collar crime. So with that in mind, I'd like to kick off the discussion with you, Nicole. Vincent mentioned that you and a bunch of other law professors banded together and started filing grievances in New York State against prosecutors who committed misconduct. And so I'd like to turn it over to you to just tell us a little bit about the group, how it started, and really what you were trying to accomplish in terms of the grievances that you selected and that you filed.
Well, first, let me just start by saying thank you to you, Courtney, to Susan, for being here and having this conversation, to Vincent and everyone who helped organize this. I see some of my colleagues past and present, some of my students in the audience, and I just want to say thank you for being here and engaging in this conversation. So for me, this connection to Accountability New York, which is the name of the project involving these law professors, and my interest in prosecutorial accountability really stems from my experience at having been a public defender in the Bronx, working in a clinic with students who work on wrongful conviction cases, who see what happens when a prosecutor's decision-making impacts the life of someone who's accused of a crime. I also teach in the doctrinal space professional responsibility, criminal procedure, and whenever we have these conversations with students about wrongful convictions, the role of the prosecutor, inevitably they have a lot of questions, right? They want to know, how did this happen? You know, what was the impact on the person who was accused? And what happened to the prosecutor whose actions had such an impact on having someone lose years of their life in prison and destruction to their family and their community? And those are really important questions. And I don't think they're questions that our profession asks enough or cares enough about, quite frankly. And that is really troublesome, especially when we think about the fact that our profession is supposed to be a self-regulating one, which means that we have these ethical standards that we are holding ourselves to, and that it's our responsibility to hold each other to those standards. And so as a professor and someone who works in this space, I think I just got a little bit tired of that disconnect and band together with this group of other law professors, as well as folks who are impacted by wrongful convictions, and attorneys at the Civil Rights Corps, which is an organization that does impact advocacy for marginalized groups, to figure out what way into this problem. Like, what could we do to address this open secret that everyone knows, that prosecutors who are engaged in misconduct really face no consequences at all. And that's not to say, of course, that there aren't prosecutors who try to do their jobs with integrity and live up to the highest standards, but we have seen the numbers in terms of wrongful convictions, so we know that there is a tremendous amount of misconduct happening. So in 2021, it was when we sort of first began to engage in this project. And the approach that we took was to use the process that exists, that's supposed to be the mechanism for addressing when an attorney doesn't live up to their ethical standards. And as you mentioned, prosecutors have tremendous power. And with that comes a high degree of responsibility, right? And so, who's holding them to account for that? So we filed grievances. Now, these weren't grievances that were based on cases that we were involved in or that we personally knew any of these prosecutors. They were based on court decisions. And so essentially we did a tremendous amount of research to find court decisions where judges found that the behaviors prosecutors engaged in amounted to misconduct, so much so in many of the cases that they had to overturn the convictions, right? And so here we go. It's not us saying, oh, this was unethical. Here's a judge saying, okay, there's something fundamentally wrong with the way you handled this case, and therefore this is the result. So we filed those grievances in the various grievance committees that are associated with the appellate courts. And we can talk about sort of how that process went, but that was how we went about trying to approach it. And I will say that in the kinds of conduct that we're talking about, right? It's not turning over evidence, right? It's discriminating against potential jurors who, because of their identity, their race, their gender, prosecutors are deciding not to put them on the jury. So those are the kinds of things that we're talking about, and things that in any other setting would perhaps amount to misconduct. You get disciplined in your job if you did something like that. And so those were the issues that we brought to the attention of the grievance committees. And spoiler alert, we're still in the same posture as when we started. We know nothing about what kinds of discipline, what kinds of actions the grievance committees took to deal with those individual prosecutors.
Or if they took any action at all, right? Okay. And can you talk a little bit about who the people were? I mean, obviously it sounds like you did a lot of research to identify these court cases, and I think it's important to understand that the significance here is not that you and your colleagues decided that something was unethical, but a court found that something was problematic enough to merit overturning a conviction. Can you talk a little bit, though, about who are the people who were affected here? I mean, are they people who were the focus of exonerations, or are they people who maybe we might not necessarily even have heard of because their exonerations were not covered? Mm-hmm. Just to get a sense of who we are talking about here, whose lives were impacted?
Absolutely. Yeah, both, so there's some cases where we read about it in the paper, right? And we know, oh, wow, that person served 25 years only to have, this piece of evidence that was previously suppressed come to light. But then there are lots of folks that you would have never heard their names or know anything about them. And, that some of the instances were not even as, flashy as a missing piece of evidence, but, a prosecutor making a misleading argument during summation, right? And largely, I would say the folks that we're talking about, you may not be surprised, are very representative of the folks who are in the criminal legal system. They're Black, they're brown people, a lot of them disenfranchised. And so they're the kind of folks that the rights that our system affords are meant to protect, and unfortunately, it's really fallen short for them.
And I wanted to go back to something you were saying. When you decided to do the research, was there any sort of strategy in terms of deciding that you were going to focus on a particular borough first? Did you file grievances exclusively in New York City? Can you speak a little bit to how you guys thought about that?
Right. So as it turns out, there's misconduct that happens everywhere, and not even New York State, but we were focused on New York State. New York City is definitely where we started. The first batch of grievances that we filed were related to Queens County, and not that there was any particular, vendetta against Queens, but it just so happened there was a lot of material to work with, unfortunately. And I think Queens has probably been in the press a little bit more, maybe, than some of the other offices. And so that many of the first group that we filed came from that county. However, as the project has progressed, we have filed grievances in all 5 boroughs, in counties outside of New York City as well, which I think goes to show how pervasive this issue is.
And can you ballpark roughly like the number of grievances that you filed to date?
I would say it's somewhere in the 50 or 60 range.
And because this matters for our discussion later, which we're going to circle back to, you publish these grievances online for the public to see. Is that right?
Yeah. Key details. So along with filing the grievances, we did create a website called Accountability New York. It's still up, accountabilityny.org. And so if you want to take a look at how the grievances were crafted, what some of the issues are, and a lot of the media that was sort of connected to all of this, that's a good place to check out.
Great. So bookmark that because we're going to come back to that. Susan, I'd like to turn to you now. As Vincent mentioned, you are the commissioner for the New York State Commission on Prosecutorial Conduct. It's obviously sort of new. I mean, it was, I guess, passed initially in 2018 or 2019. But it's just now getting off the ground for reasons that we will also discuss. And while you obviously are not going to be able to talk about individual cases, could you start off by telling us what the commission is empowered to do with respect to investigations of misconduct, and what the public might expect to see, generally speaking, for the investigation and fact-finding process?
Sure. Well, first, thank you for the invitation to be here. It's really an honor to have the opportunity to speak with all of you about the Commission on Prosecutorial Conduct. I am the inaugural administrator. The commission, despite, as Courtney has alluded to, having the first statute that created it be created in 2018, we did not actually get off the ground until 2023, last March, when I was appointed as the administrator. So next week I will have been in this position for 1 year. So it's really great to be here and have this opportunity to talk about the work that we're doing. So the commission, as some of you may be familiar with, the Commission on Judicial Conduct, we are modeled after the CJC. There are 11 commissioners. They are unsalaried members, and they are appointed by the 3 branches of government. The governor appoints 4 individuals, the legislature appoints 4 as well, and then the chief judge appoints 3. We are authorized to investigate any allegations of prosecutorial misconduct in New York State in all 62 counties. We, our work stems from our enabling statute, but we do operate slightly in the dark, in the sense that our work does not become public or until we reach a finding. And so the way this process works is that we would receive a complaint, and it would start going through the complaint process, where we investigate the complaint only after the commissioners authorize an investigation. And then if we go through and reach a decision that a formal complaint needs to be brought, a formal complaint is brought. And it really, when you read our rules, it looks like it's an adversarial process where it is the staff versus the prosecutor, but it's not really meant to be that. It's really meant to be a truth-seeking process because of the importance of accountability in New York State and everywhere. So that's the work that we do.
And can you talk a little bit about the decision-making process? So you mentioned that, obviously the commissioners vote and they're non-salaried. If you take a quick look on the website, you can see the names of the commissioners. They're appointed, obviously, like you said, some by the governor. There are a very diverse group of people who you might expect would not always agree on whether or not a given an allegation merits an investigation. So I guess is there like a majority voting rule? Like how do you go about sort of getting consensus, if you will?
Yeah, so the way the commissioners are appointed by statute is designed to have a balance of interests, both to represent the prosecution perspective and the defense perspective, and then there's also an academic perspective as well. I think that even though you would look at the commission and see that they're split, when you look at egregious allegations of misconduct and you follow the evidence, if the evidence seems to demonstrate that misconduct did occur, there's more consensus than you would think. And so even though they do represent a diverse range of interests, I find that the commissioners agree more than people would expect that they would.
And you mentioned when you find the evidence. So does that, can you talk a little bit about the investigative tools? Because I think one of the things that makes you unique is sort of just how the enabling statute equipped you to conduct investigations.
Yeah, so the commission can do a full range of investigative functions. We have subpoena power, so we can subpoena witnesses, we can require documents to be turned over, we hold hearings. So there's a full range of steps that we can take to reach a final resolution. What this basically looks like is as I said before, when a complaint would come in, the commissioners would decide whether or not they're going to authorize an investigation. I think one thing that's really important for the public to understand is that it's not unilaterally me as the administrator or the staff making any decisions about whether or not an investigation is going to move forward. This is a decision made by the commissioners. And that way, I would hope that, even though, oversight is uncomfortable, that prosecutors would feel much more comfortable knowing that we do have input from all of the commissioners about moving forward.
And then can you talk a little bit about what a final sort of work product would look like?
So that, of course, would depend on the case that we're looking at. But essentially, if we end up in a formal hearing and we would have a referee who would listen to the evidence both from commission staff and the respondent prosecutor. What ultimately happens is the commissioners would receive a recommendation of findings and recommendations report. They would decide whether or not they accept the findings and recommendations or whether or not there should be changes made to them. And ultimately, they decide what the appropriate findings and recommendations will be issued by the commission. Once that happens, the key difference between the CPC and the attorney grievance process is that our findings are public. So they will become available online for everyone to see what the evidence was, what the decision was reached, and why we reached that decision, which is really important to public confidence and increasing people's general opinion about the criminal legal system.
And then just two more quick questions based on what you had said about public findings. What is the range of possible sort of sanctions that the commission is empowered to recommend or impose, if you will? And then you talked about differences between the grievance committee and the CPC. Can you speak a little bit, because there is some overlapping jurisdiction here. If you could talk a little bit about the relationship going forward, I guess, how you anticipate the CPC and the grievance committees sort of interacting or working together or not working together?
So one of the reasons why there was a delay in the CPC launching was because there was a constitutional challenge to its creation back in 2020. And the challenge was that there was an issue with separation of powers, because at that time, by then the first enabling statute, the CPC was empowered to actually sanction prosecutors, very exactly like the Commission on Judicial Conduct. That was challenged in court, and the court did find that this violated the separation of powers. And so as a result, the statute was rewritten, and now the commission can make findings and recommendations, but it's up to the Attorney Grievance Committee to actually decide what they are going to do with those recommendations. So that is a limitation of what the CPC can do. We can't actually impose discipline. In terms of the Attorney Grievance Committee, we are two independent oversight bodies that operate, confidentially, and so, they do their work and we do ours.
So I think let's circle back now and talk about the reaction to both the CPC and the work that Accountability New York has been doing. I think it's fair to say that both of your organizations have received some pretty considerable pushback and opposition from a variety of different sort of actors and policymakers across the legal system. So just sticking with the commission, you've already alluded to this, but before the commission was enacted, the District Attorneys Association of New York issued a statement that opposed its creation. DASNY claimed that the commission was going to have a pernicious effect on public safety because the commission would provide an avenue for defendants accused of the most serious crimes, or really anyone with an axe to grind, to file frivolous complaints. Then after the commission was enacted, as Susan's already mentioned, DASNY actually filed suit to block it from taking effect, arguing that it violated the Constitution's separation of powers. And then more recently in 2024, DASNY and others, legal commentators, have suggested still that there's a constitutional problem and that there are just fundamental issues of fairness here because the Grievance Committee has already been doing this work, and so therefore the CPC is duplicative of the grievance committees. Can you respond to those criticisms, including the idea somehow that the Commission on Prosecutorial Conduct would actually somehow harm public safety?
Sure. So I'll start with the concern that we would receive frivolous complaints. I think there are a few responses to this and a few ways I think about this. First, I think it's important to remember that anyone can file a complaint to the Attorney Grievance Committee. It's not like there is some rule that a defendant cannot file a complaint to the Attorney Grievance Committee. So in that sense, there's no daylight between us and the Attorney Grievance Committee. But more importantly, I think there are frivolous charges every single day in courts, in civil cases, all across the country, and it is a responsibility of people who receive those complaints to look at them and determine whether or not there's any merit to them. If we receive a frivolous complaint, we will in fact dismiss it, but that doesn't mean that we shouldn't exist and we shouldn't have our doors open to everyone to file complaints to be heard, which is a really important part of all of this. And I think the other thing that I would say about whether or not accepting complaints from people who would have an axe to grind is, I understand that the CPC is an unknown to prosecutors and to everybody because we haven't done anything yet. But I really do think we should be given the opportunity to do some work and to show how we're going to function and to prove to everybody that we're going to operate in a fair and just way before there are any of these assumptions made about what we will or will not do. On the issue of public safety, I've not had an opportunity to have a discussion with folks from DASNY yet. I hope to about what their concerns are. If I had to hazard a guess, I think it has to do with ongoing criminal cases and whether or not we would interfere and in some way undermine their case. And I think here there are also a few responses. First, it's important to recognize that the statute itself has protections for ongoing criminal cases. The CPC is only permitted to operate in a way that will not interfere with an ongoing criminal case. And there are a number of protections in the statute for ongoing criminal cases, which also includes opening up a dialogue between my office and any prosecuting office that we may be working with. I think the second thing, kind of just going back to give me an opportunity to do something before you start throwing tomatoes. Don't assume that we're gonna harm public safety. This is not an evidence-based criticism. We haven't done anything, so they can't point to any way that we have interfered with a case or undermined public safety. And I think the last point, and this goes back to what you were mentioning earlier about the diverse range of interests with the commissioners, it's not solely within my discretion to determine whether or not an investigation goes forward or what a sanction what kind of sanction will be recommended. It is this diverse range of commissioners, and they are going to be there to make sure that public safety is not undermined by the staff's by any steps that the staff has taken. In terms of the difference between us and the Attorney Grievance Committee, and that we are duplicative of them, I think the biggest difference is the transparency, and I can't stress enough how important that is with the work that we do, because prosecutorial misconduct has a huge impact on the public and how they see the system. When you hear about prosecutorial misconduct, it ends up, people become very, there's a cynicism associated with it, and then they don't trust the entire system. So even though prosecutors may not like oversight and it may be unfair, it is actually really important for this reason to increase public confidence that they operate with transparency.
And I'm going to return to DASNY a little bit later because they issued a lot of public statements that are there's a lot of fruitful discussion there. But I want to turn to you, Nicole. We had earlier mentioned that you published the grievance complaints that you filed online, and your group received pretty immediate blowback. As soon as those grievances went live, the Office of Court Administration described Accountability New York as engaging in a publicity stunt. OCA and the New York City Law Department also suggested that you were somehow politicizing and misusing the grievance process to achieve policy change. And then, obviously some of these grievances that you mentioned, there was a lot of legal fodder from Queens. And so the Queens DA, Melinda Katz, criticized the grievances because they relied on old court papers and because Accountability New York didn't have any personal knowledge of the cases or the parties. And I'm just wondering, what's your response to those criticisms?
It's all very on brand, right? I can't say that I was terribly surprised, but disappointed in some ways. Because I think to call it a publicity stunt sounds like, we're YouTubers jumping off a bridge or something like that. It's so not representative of the fact that you have law professors, attorneys, impacted people who are raising these issues of concern. And so I think it was, dismissive, it's discrediting. I think it was honestly an effort to silence us and to have folks back off of these efforts. But it's just interesting because, what they couldn't say was that, this wasn't actually misconduct, right? There were court decisions that said it was, right? So they couldn't say that. They couldn't, I guess they could have, but they couldn't acknowledge this happened. We did nothing about it because that is the truth, right? And so all that's left at that point is to attack the messenger, right? And so I think that is really what it was about. And to me, it was representative of the system kind of doing what it does when it gets challenged, which is to, sort of insulate itself and take on a protective stance.
And I guess I wanted to follow up on something that obviously was not your words, it was New York City's, the OCA and New York City's Law Department, about somehow that you shouldn't use the grievance committees to achieve policy change. And that sort of piqued my interest because we're going to talk a little bit about that in a bit, but what do you think they meant by that? I mean, on some level, the grievance committee is in the business of making policy if they were to publicly announce, sanctions or not publicly announce sanctions. So it seems like it's all sort of some level of policy. I mean, do you understand what they were suggesting there?
I can't tell you exactly what they were suggesting. I mean, I know that the grievance committees have a range of options in front of them anytime someone files a grievance. And so, if it was something that they wanted to refer to, a bar association or a commission or anything else, that is within all the range of possible things. I guess, when we think about accountability, and it is very much perhaps a prosecutorial mindset, we think about punishment, right? And I think consequences and punishment certainly are warranted in some situations, but I think it is also an opportunity when someone raises a red flag and raises a concern where efforts haven't been taken before for them to step in and do something. So I can't tell you exactly, what they were getting at with that statement, but I do think there are always opportunities to make policy change.
So continuing with that, I think the biggest thing that the law department actually ended up doing, though, was that they tried to sever the group from the grievances that were filed, which is to say they wrote a letter to the grievance committee and said that the grievances should be treated as if they were sort of started as investigations by the grievance committees themselves, and therefore there were no interested parties attached, and that they should stop and cease all communication with Accountability New York. So can you sort of talk about what Accountability New York had to do in response to that, to those actions taken by the New York City Law Department?
Right. So there was a letter. The letter was to the grievance committees with a helpful CC to all of the law professors who had filed the grievances. And so when we received that letter, and especially some of the language within it that suggested we had broken the law or abused the process in some way by publishing the grievances, we did what folks do when you get something a little threatening, you get a lawyer, right? And so we were fortunate to be assisted, both the lawyers and Civil Rights Corps, by the good folks at Patterson Belknap, who, tip of the hat to them, amazing lawyers. And there was, sort of this back and forth dueling of letters, especially once we got a response from one of the grievance committees saying that they were going to do, in fact, exactly what you suggested, treat the grievances as being sua sponte and taking the investigation on independently and dismissing us from the process as complainants, which left us in a position of not having any right to know anything about what they did or did not do or what the outcome would be. And so after that happened, we had to file federal suit, basically, in the Southern District. And two of the issues that were of most importance in that suit was about the publishing, our First Amendment rights to be able to publish our own grievances on a website. The court found in our favor as to the first issue about publishing the grievances, and that was probably in 2022 or so. And so after that decision, we continue to file and publish grievances. And more recently, in 2024, we got a positive decision, again, in terms of us having a right to get the outcome of the grievances that we filed. And it really goes to what we were talking about in terms of if there's no transparency in the process, if the people who filed the complaint can't get access to that information, how can you have any confidence in how the process went forward? The state has appealed that decision, and so litigation is ongoing.
And I neglected to ask you this at the outset, but I know there are a lot of complaints, so you may not know every single prosecutor, but I mean, are you aware of whether or not, what has happened to the prosecutors that were the subjects of these court decisions that led to the grievances you filed?
I don't know for all of them. I can tell you as a general matter, just sort of referencing at least the attorney registry and the discipline detail page, none of the prosecutors who we file grievances on have any record of public discipline that's been posted on that site. As a matter of fact, for many of them, they've been promoted through the ranks, right? So not only do they have these decisions and these findings, but they find themselves being bureau chiefs or going out and having all kinds of other jobs. So as best I can tell, very minimal consequence.
I mean, I'll just note that one of the grievances that was drafted by Accountability New York was selected. I had to select it for CLE for everyone who wants CLE, and so I encourage you to read that grievance, because when you look at who were the subjects of these grievances and what happened to them afterwards, the grievance that I happened to select was from someone who's now retired, but who for a long time headed the Conviction Integrity Unit in Brooklyn, and who was himself the subject of one of these grievances. So I want to sort of talk more about the pushback that you all have received, because even though you receive this pushback from different actors, I think there's sort of a common theme here, which is, when you read DASNY's statements and you read OCA's statements, they all sort of start off the same, where they say, like, we agree with you that it is super important to hold prosecutors accountable, but we just don't like the way you're going to do it. And so it seems like at the end of the day, what they just want is to return to the status quo, right? And you mentioned this about the system circling the wagons, if you will, and being insular. And so I'm interested in sort of understanding that common response, which is, we agree it's important, but your solutions are bad, and the solution that we propose is just more of the same, the status quo. And so I guess I'm wondering, like, why do you think there is such resistance to both of your efforts to try to change the way New York handles prosecutorial misconduct and addresses accountability?
I think when you are one of the most powerful actors in the legal system and you haven't been held to account, there's not a ton of motivation to change that, quite honestly. I think, the whole, we just don't like the way you do it is so interesting, because we did it in the way that it is supposed to be done, right? And so to say, oh, but that's old, or, you did too many of them at once, or you don't know them, like, at that point you recognize it is not about the way you did it. It's not about the process. It's about the substance of it, right? That you kind of broke the open secret and the understanding within this profession, which is really, like, we are a protective profession, right? I think why we were in a position as law professors to file these grievances is important to understand too, because people who are constantly in the same courts and interacting with these same judges and DAs all the time really are discouraged from filing grievances, because it's going to harm their next client, right? And so they're thinking about that as well. So the best that I can speculate on this is that, no one wants to have their power limited, right? And even though they recognize that there are issues, they think they're able to manage those issues, or they're sufficiently isolated. And I think, we've gotten to the point where we recognize that that's not true.
I think what I would add to that, and you alluded to this, just is oversight is hard for everybody. Nobody likes it. And I think that's especially true when we operate in a legal system that focuses on blame and punishment. So here it's difficult for prosecutors to see the benefit of oversight, that perhaps by learning about, the conduct that leads to unlawful outcomes, if you want to put aside the intentionality, at the end, they are leading to unlawful outcomes. You should be interested in that conduct and ways that you can learn from that to elevate the practice in your office. And, because there has been this pushback, and because there's this general resistance to any kind of oversight, that puts a responsibility on the commissioners and on me to make sure that we get it right and take the steps to show that we are going to engage in this process in a fair way, and that hopefully will start to change the culture, and maybe one day they'll be more open to oversight.
And this seems like a good time to sort of ask just the on-the-nose question, which is, like, would we be better off, instead of trying to fight this fight with filing complaints and then having people sort of throw firebombs at you, or having the CPC, just to play devil's advocate, would we be better off just trying to change the way the grievance committees operate and just have better grievance committees? What's your response to that?
I think that could be part of this. It's not going to be the entirety of the solution, but I think that could be part of the solution. And I think it's important because nobody really understands how the grievance committees operate, and who's on them, and are there folks who are sufficiently close to criminal practice to be able to understand the nuances of the particular issues that come up. I think even the joke in teaching professional responsibility is that the thing on the MPE they care most about is, like, commingling funds, right? So it just feels like there's always this concern about things that are really outside of the criminal process. And so I do think that there are some improvements that could be made, but certainly that alone is not going to do it.
So now I want to keep talking about pushback, and now I'm going to bring DASNY back into this. And I want to talk about pushback specifically and link it to the term prosecutorial misconduct. and how we should think about the term, how we should think about defining it, because it's not, it's not a legal term of art, and so it doesn't have any sort of settled legal definition. And because of that, I've seen criticism that this is just an empty term that's designed to scare the public, it's designed to mislead policymakers, and that it's used to overstate a problem that is in reality sort of limited and discrete, right? So, our center does a lot of work on prosecutorial misconduct, and in that capacity, we've read a bunch of cases outside of New York State. The Pennsylvania State Supreme Court said recently, I think in 1998, that the term prosecutorial misconduct has been so abused as to lose any particular meaning because it can be used to describe everything from serious due process violations to more minor trial errors. And then to go back to DASNY, closer to home here, in their public statement against the CPC, they criticized the term for being widely and promiscuously used by law enforcement critics to describe every miscue by a prosecutor, regardless of the prosecutor's intent. And then they went on to say that because willful prosecutorial misconduct is extremely rare, there was just no need for the CPC. And so when you sort of take these arguments together, it seems to be that critics want to attack the use of the term and people who would say that we need change because of prosecutorial misconduct, because the term is just alarmist, it's empty, it overstates a problem. So can you guys sort of respond to that? Like, I'm interested in how you think about the term misconduct and what it means. I noticed you use the term illegal outcome, right? And then you unlawful outcome, and then you said cabining intent. And so I think there's room here to talk about, like, what do we mean when we're talking about prosecutorial misconduct? And then, for you and Accountability New York, like, when you saw the different types of grievances that merited new trials, like, if you can talk about the role that, like, we think intent should play or shouldn't play in how we think about what is or is not misconduct here.
Sure. So I think they're trying to commingle this, right? Prosecutorial misconduct and the intent. And I think that these are two separate and equally important questions for society, right? For us to care about, because the term prosecutorial misconduct, yes, there is no technical term. If you Google it, you'll find a million different things, but largely it is defined in courts, right? As you had said, these are courts saying this is prosecutorial misconduct. This isn't me saying it. It's not Courtney saying it, right? These are courts. And so it does encompass a wide range of activity. And while some activity, some conduct, is maybe more damaging to people, it all matters in the system, right? Because we don't want these unlawful outcomes. A constitutionally infirm trial should matter just as much if the person is guilty or whether or not someone is guilty or innocent. Like, as a society, we should just care about that. And so, in that sense, I do think we need to separate these two questions and kind of think about, first, was there a misconduct that happened in this case? And then second, we can get to the intentionality question, because I do think that there is a difference between a good prosecutor who had a bad thing happen and a prosecutor who hid evidence or destroyed evidence. And it's important for us as a society to capture both, to get answers to both of those questions, again, especially if you want to inform policies and practices in DA offices so they can prevent these unlawful outcomes from happening.
I agree completely, and I think to the point about intentional and it being so so narrow and so few and far between. How do we know? Like, how do we know, right? We know a little bit based on some of these court decisions that we're talking about, and certainly there are ranges of behavior, but there is so much we don't know in terms of what a prosecutor's conduct is, because they hold all the information, right? And sometimes when we get access to it, it's almost like a strike of like luck, So, and then we're talking about trial cases. What about the fact that all cases plead out? Practically, right? So there's this whole range of conduct that we have no way of having any sense about. So I appreciate that talking about it in this way is like, oh, it's just a few intentional actors, and really trying to narrow in on the language is an effort. But I can't even conceive that, because I feel like there's so much that we really just don't know. In terms of us, the project, and how we thought about it when filing the grievances, Absolutely. You know, it's not all conduct is the same. And I think the word misconduct, at least in my mind, is open enough that it can encompass a range. You know, there can be, you know, one end of it serious, the other end is, you know, less serious perhaps. And maybe that factors into what kind of sanction or recourse the grievance committee might take. And that certainly factored into the way we crafted the grievances and what we were asking for as what we thought the appropriate outcome would be. And so it does matter, but I also don't think we should get terribly bogged down in it, because the impact that it has for how we think about the system, the profession, the people who are, you know, touched by these kinds of situations, I don't know that it matters terribly to them.
Right, and you brought up something that I neglected also to mention at the start, which is I think the majority of the grievances that Accountability New York filed were based on cases that had gone to trial or were in the trial process, right? So we are in a super, super limited world of cases that go to trial, and I'm sure that most of you in the room know that no cases go to trial, right? Like upwards of 90% of these cases end in pleas, and so I think it does illustrate a good point that I'm not sure how we know whether or not willful prosecutorial misconduct is extremely rare or not. We just don't know the denominator. So I want to talk a little bit about, we were talking about policy before and policy change and using individual grievances against individual prosecutors to affect sort of larger scale policy change. And I want to harp again a little bit on DASNY, sorry DASNY, because I think DASNY's sort of public statement coming out against the CPC sort of, I think, illustrates like two frameworks here, and I want to talk to you about these frameworks for how we can think about misconduct and accountability. And I think these frameworks are important because obviously depending on which one you sort of focus on, it's going to influence the policy solutions that you think are important, right? And so DASNY talks a lot about like individual willful prosecutorial misconduct being extremely rare, and that evokes immediately like a focus on an individual prosecutor in an individual case and asking what is this prosecutor's intent. And it, you know, I think in other statements they suggested that yeah, there are lone bad apples out there, but that's, you know, that's rare, and so therefore if that's rare we don't need a whole host of oversight, right? And so that's sort of like an individual framework where you're focusing on the individual. But I think another way that you and Accountability New York maybe were approaching this is in filing these grievances, like in Queens, you're not necessarily concerned with any given prosecutor, although obviously the grievance committee mechanism is by individual prosecutor. It's not grievance against the Queens DA. But I think another way to look at this through what you're doing is that we're trying to like lift the hood on an office, right? And we're trying to pull back and say, is there a systemic or institutional problem here? And it might be like, you know, I'm going to draw on our center, did a lot of work looking at prosecutorial misconduct in Philadelphia. And so it might be trying to understand like what was the office communicating to its prosecutors about what it should be doing in cases. And this sort of goes to the prosecutorial misconduct and whether or not the term is scary or not. In Philadelphia, we had the head of homicide saying that it was their belief that they didn't have to write down or disclose any statements from eyewitnesses that they didn't believe to be true. And that, yeah, no, he wrote it in an email, and, you know, obviously they were lucky that they got this email. I don't know, but I could presume that maybe there are other interpretations of Giglio and Brady that comport with that, and you will never know because it's not written down in an email. But that's all sort of to say, you might know though if you start pulling out grievances and looking at them across this, right? So there's like this individual framework, and then there's this sort of systemic framework. And I guess I want to know, like, do you think it's possible to sort of reconcile these two frameworks, or how do you think that they should come to reside, like, with the CPC and with the grievance committee? Because I think that they're both legitimate, because obviously discipline should be imposed only for what you do, not for what, you know, the sins of the office or whatnot. But I also think that, you know, you could get policy change if you would start to look across offices and in specific time periods to see whether or not there were certain common approaches to like interpreting Brady or how you went about striking jurors. And so I guess I want to sort of get your sense about what you think about this, like individual versus sort of systemic institutional framework.
I mean, I'm going to give a very unsatisfying answer, which is similar to what Nicole said, which is we just don't know which one is true. Look, I have a science background, so I'm really big on data. And to take your example of Brady, if offices would routinely collect information about every Brady allegation that was made in their office, the steps that they took to investigate it, the resolution of that investigation, and what they did, and publish those results, then we could answer this question. But at this point, nobody is, as far as I know, not doing it, but that's what the CPC brings to this. What we are going to be doing, we publish an annual report every single year, and what we are going to be doing is providing these statistics, and so we can get a better picture of what is going on and look for trends in offices. Is there a problem with Brady in an office? Is there a problem with the way all prosecutors are making summations? Or, even if it's just one prosecutor who is routinely making inappropriate arguments in summations, they should want to know that. But I think just right now, trying to reconcile these two is really difficult because we just don't know what the reality is. We just know what everyone's perceptions are. And as you said, everyone is coming at this from a different perspective. And so it's just really hard to figure it out, I think.
Yeah, I think that is true. And it is hard because there has to be a connection between them two, right? It's like it doesn't have to be one or the other. And very often, if you're seeing one individual prosecutor coming up with this issue, if you're seeing two, it's really a sign that you might want to look a little bit, more closely, right? That makes sense. That's how we look at the world. Like if, one car has a defect, 2 cars, 3 cars, okay, maybe we need a recall and take a closer look, right? And so I do think it is an opportunity to have a little bit more policy, systemic examination of these various offices. I think what that butts up against sometimes is this, culture or perception of infallibility, right? That they kind of get it right all the time, or that there's like a moral, there's just moral conviction such that if you let down that veneer at all, it threatens the entire endeavor. And I appreciate that many offices have now started to develop conviction integrity units and are open to collaborating on some cases that reflect wrongful conviction, but I think it does have to go a little bit further.
And so I kind of want to talk about the prosecutors' offices now themselves. I know we've talked about DASNY and the criticisms, but you mentioned that you're going to be collecting information about Brady and publishing, or not just Brady, but that's an example of the data that you'll be collecting and able to publish out there. And it just made me think, do you see room for prosecutors? Not every prosecutor's office, but there's this movement where prosecutors say that they're progressive or that they are into reform and that they recognize that the way things used to be in their office was wrong. I'm not saying that those prosecutors actually exist here in New York City, but I'm saying the hypothetical prosecutor who might be open to this. Do you see a world where prosecutors could be involved in policing themselves more? I mean, you say prosecutors should be collecting information on Brady. They should want to know if a court of appeals comes back and says this ADA engaged in improper summation. It seems like there's room there for prosecutors to take steps to sanction line assistants, because after all, they can take that action as their boss and employer. So I think, how positive, skeptical, cynical are you about the idea that there's room for prosecutors to sort of do a better job of self-policing, where they obviously did not self-police before at all?
I think if they, this is tough, right? Because right now what they're saying is just trust us, right? Trust us, and we're not seeing any policy changes coming out of their office. I think if they did what I suggested and started publishing data and letting the public know what they're doing about what they're learning, then yes, there is room for that. And, it's a great step that there are conviction integrity units, and that, they're, learning lessons and presumably teaching that to the rest of the office, making these office-wide, teaching it office-wide what they've learned. But I really do think that until they take these steps to take an interest in learning what the allegations are and investigating them and making that information public, until they start seeing the value in transparency, I think it's going to be really hard for them to police themselves.
Yeah, I'm having this whole like internal debate, and I'm like, be hopeful. No, you're a cynic. I'm trying. I think they're, like I said, some of these conviction integrity units are doing some good work, but I just looking at the history of where we've been and looking at the responses when confronted with opportunities to bring about more accountability, it doesn't make me incredibly hopeful. I do feel that having some independent outside mechanism is necessary.
I just got told that I have to end for CLE purposes so that we have time for audience questions. So I want everyone to thank Susan and Nicole and join me in thanking them. Does anyone have any questions? There's a mic that's going around that Hallie can pass to you.
Thank you so much. This has been great. I'm a supervising attorney at the Office of the Appellate Defender. I started as a staff attorney at Appellate Advocates. So that's first department and second department, the 5 boroughs. And Susan, I was really happy to hear you mention summation misconduct. I think that is what we see the most often. If you pick up any given trial file, you will see summation misconduct. It is intentional and willful, like prosecutors are saying. Sometimes just a couple, bad comments, and some, and pretty frequently pretty outrageous stuff. And so I guess it has felt like this is on no one's radar, so I'm really happy you said it. But it's tricky because the New York courts turn a totally blind eye to it. At most, you get the second department saying we're reversing anyway. While we're doing it, the prosecutor should never have said anything like this. Otherwise, I don't know of any appellate courts that are saying we are vacating this conviction because of summation misconduct. The last time the first department did that, I think, was in 2016. So given, I guess, Nicole, the approach that you have taken where you're relying on the courts to make a finding before you're going forwards, and given that this is not like, it's not wrongful convictions in the sense of actual innocence, but it leads to wrongful convictions because often you see the prosecutor making the most outrageous comments where the evidence is thinnest. Mm-hmm. I'm really curious at the appeal system is not doing anything with this. I'm curious about other strategies to get at this because it is so common in New York. Mm-hmm.
Thank you. Summation misconduct has come up quite a bit in some of the grievances we filed, and they're usually also in combination with some other thing that's happening. And so I don't know the answer because we started in this way because we felt like, oh, this is unassailable if a judge has, but there's clearly a universe of all other kinds of things that we would want to be able to include. And so maybe as the commission is more of this issue, but I agree with you completely. It's really hard because judges don't recognize it nearly enough. And there are a host of offenses that are happening in terms of prosecutors that they don't recognize enough. And the limited way that we found this intervention that we thought was the most unassailable, that still is assailable, doesn't even get us half the way there.
I mean, one thing I would just add, I agree with everything that Nicole said, is that you make a really good point, which is that a ton of misconduct happens in open court every single day. And the only thing that makes the headlines are, in some ways, understandably, those wrongful convictions. But yeah, and that's something that we, at the CPC, we will, right? We are not just, we're here talking about prosecutorial misconduct, but I also want to remind folks that we're the Commission on Prosecutorial Conduct, right? So we are looking at all things that prosecutors do, not necessarily just case related. There's like a range of conduct that could come under our purview, but we are not limited to looking at only cases where a conviction was overturned. That's certainly the easiest way to learn about it, which is why I would, even though it could be, I think Nicole, you may have mentioned this, that it could be, a lawyer could be nervous about filing a complaint when they see something in open court for fear of retribution for their own client. if we don't know about it, we can't do anything about it. And I know that's hard for some lawyers, but it really is important for us to learn about what's going on in court, because we can't be everywhere and learn and, you know, to police all of this.
I'd just like to add that I think that, to your point about the misconduct sort of going unnoticed or unaddressed if it's not attached to something more serious, I think this is where the data could be useful, because I could imagine a world in which you publish, the CPC publishes a report that starts to talk about which office is having like serious summation problems or serious, you know, other non-Brady, non-Batson like problems that we might not think of as serious, but there it is in a report. I mean, I think it depends on who the head district attorney is, but I think it becomes a pressure point for people to say, what are you doing to train on this? Because you clearly have a systemic problem, right? I know that's not satisfying because that still requires some level of self-policing by the DA, but at least now the public has data. And I could imagine a world in which it gets harder to argue that the error was harmless if you have data suggesting now from the CPC that this has been going on for quite some time. So that it's like an incremental thing, but I imagine it's a better thing because now you have data where you didn't before.
Thank you. Very, very interesting discussion. I'm curious about the decision to look at decisions, file grievances, and then publish the results. And obviously, I think transparency, obviously this all gets hidden under the rug, so it's really important to get it out there. But I'm curious, in setting up your system and making the decision to do that step, to publish them, what specifically did you hope to accomplish, and who was your audience that you were trying to communicate to?
Mm-hmm. Yeah, so it's in publishing the grievances that we filed, it was taking the information from these court decisions that is really sort of buried, right? Like people aren't named necessarily in court decisions. Most folks in the public aren't really combing through court decisions in any particular way. And so the audience really, I think it was a public education push as well, right? There was media connected to the effort, and I think it gave people a little bit more insight into the kinds of conduct that go on in our courts. Like we know about these concepts of mass incarceration and wrongful conviction and, you know, all the rights that people are afforded to, but it gives a little bit more context and nuance to understand how it's actually playing out in particular cases. And so I think it was really an audience for the public. It's an audience for other lawyers who are aware of these things that are going on but feel that they can't really be in a position to do anything about it. Like I said, it's this open secret about prosecutorial misconduct, and I think it was an opportunity in many ways to lift the veil on some of that.
Hi, I wanted to ask a question about the psychological impact that is profound on people who are wrongfully convicted. And I wanted to know if you guys directly work with any like outreach programs or groups that provide mental health resources for these people who are wrongfully convicted, or do you have liaisons who indirectly work to help them and help them readjust to society?
Mm-hmm. That's an excellent question. I can tell you, at least in the clinic, you know, we do a combination of wrongful conviction and other kinds of post-conviction cases. And I think the resources that we have are really connected through some of the organizations across the city, you know, Legal Aid and all the other organizations that we work with. But we also have a really strong network of formerly incarcerated people who support one another. And I think that has been some of the strongest kind of peer support for people who are dealing with the weight of, you know, whatever aspect of the system has fallen upon them. But it really is an area where I think there needs to be even more supports. They're out there, but from the work that I've been doing, I think getting support from people who have been in similar situations, who've been out a little longer, who can, help guide people through the mental and the very tangible effects of all of it is what we are best able to offer.
I was a criminal trial lawyer, felonies only, in Westchester County for 38 years for the Legal Aid Society. Most prosecutors are honest, most prosecutors are ethical, some aren't. The two most egregious things I ever saw a prosecutor do, or knew of a prosecutor doing, in one case, during a trial, a prosecutor took out a pen and changed a document that had already been admitted into evidence and was caught doing it. In another case, a homicide, where the medical examiner had found natural causes, the prosecutor went to the chief of the medical examiner's department and bullied them into bullying the person who'd done the autopsy to change the results in that homicide, because it was a highly publicized case. Both of those prosecutors are now judges in the city of New York. That's what consequences are. I question, Ms. Friedman, how many findings has your commission found so far?
So we launched with my appointment about a year ago, and at this stage, I am building this agency from scratch, and so there is a lot of stuff that needs to happen before we can start. We're investigating cases right now, but before, just the investigation process takes a long time. But there's also the creation of the agency, which I think even for myself, I did not know how much went into creating an agency until I got there. And so there's just a ton of stuff from, figuring out office space and tech and, creating a staffing plan and payroll and benefits that I have to do before we can actually get into the work. Because if the office isn't set up and we don't have the staff on board, we can't make sure that we are, investigating these complaints fairly, which I know the commission, people have been waiting for a long time for us to be up and running, but we are accepting complaints now and we are doing the work. And I think if we want to have confidence in the results that we publish and we want the public to feel confident in the work that we're doing, we have to make sure that we take all of the right steps first.
I would also like to know from the three of you whether you think ending the doctrine of qualified immunity would have any effect on improving conduct.
Nobody wants to answer, huh? Yeah, it wouldn't hurt, right?
My short answer would be yes, but I'm going to stick to the subject so that we can get the proper CLE credit, which is about prosecutorial misconduct. But yeah, I think my short answer would be yes. If we had incentives in place that would change people's behavior at the front end, then I could imagine a world in which people would be much more hesitant to not engage in the email that says we don't need to take down a witness statement where they're saying stuff that we don't think is true, or the corollary to that being like we can redact a cooperator's criminal history and only include his prior offenses that relate to this case that we're prosecuting at issue because we don't want to try facts in other cases. I don't think you'd end up with that kind of terrible win at all costs interpretation of Brady and Giglio if you had people who were actually worried about the fact that they could be held liable. I think you'd take much more care at the front end. It just seems like common sense to me. That doesn't seem like it's unique to prosecution. But there was someone over here, sorry, who had a question.
I had the impression from your remarks that there were no penalties when there were wrongful convictions, that sometimes these prosecutors get elevated to a bureau chief or something like that. And I wanted to ask if you have an impression about the culture of these offices. Like, for example, you mentioned Queens, like what kind of culture is Melinda Katz, bringing to her prosecutors, or I was very impressed. I saw Eric Gonzalez, District Attorney in Brooklyn, speak right here. And I was very impressed with him that his office actively investigates wrongful prosecutions, wrongful evidence on the part of police and this kind of thing. What's your impression of the culture of these, or whether they, convictions are rewarded? I guess a metaphor to that is like a Western movie where you're notches on a gun, this type of thing.
Can I start? So, I mean, obviously, I think the answer is yeah. For a really long time, and even now, a lot of prosecutors' offices across the nation care about convictions because they're measured on their conviction rate. I keep talking about Philly only because we just last year wrote a report about 35 years of prosecutorial misconduct in the Philly DA's office, where we essentially did what Accountability New York did, which was we relied on publicly reported court cases and CIU exonerations by the Philly DA's office. And the only thing that we did was, like Nicole, we named names in our report. And I will tell you that we were able to gather a lot of information from emails, like the email I cited where the homicide chief was like, don't need to write anything down that we don't think is true. There is just a culture where they reward winning, and there was a culture there, and I can't speak to what is going on in Queens, but I want to bracket that. I think there is a culture where there's this belief that you have to win because the person that you're prosecuting is terrible. There's like a dehumanization that occurs, and there's this idea that you're the white knight and you need to do this because otherwise it's terrible and crime will go up and these are bad people, and so you sort of tell this oversimplified story. Or there's some belief that, a lot of the things that we saw in our report was that people who were targeted and ended up wrongfully convicted were known to the police, and so there was some belief that they could just manufacture a case against this person because they probably did something else bad anyway, right? So I think there is this culture of winning, and there is a culture of bending the rules in service of winning, which is how you end up with an interpretation of Brady and Giglio that is not Brady and Giglio anymore. It's like the exact opposite, right? And you end up there because I think you need to win. I will say I can't speak to Melinda Katz, but I think it was, she's the leader of that office, and I'm sure that there are lots of competing things that she had to take into account there. But I will say that she was highly critical of these, of the grievances that were filed, and that's a choice. That's a choice to come out publicly and be critical of these grievances when they are, in fact, relying on judicial findings of misconduct that were serious enough to merit a new trial, right? Because there's a lot that's running against you to get a new trial. Like, you don't get a new trial just by, alleging any old error. It's got to be serious, right? And so I think that's a choice. I also think it's an interesting choice because I don't believe that every grievance that they filed consists of someone who was actively in that office, right? So there's a choice being made there. And I think that what led to her speaking out was some statement indirectly that the New York City Law Department made, which was that they were contacted by the Queens prosecutors who were very concerned. And so I think, to speak to your point about culture, I think there's an irony here that the Queens prosecutors were concerned that their names were being attached to something that they did. They're not denying it. A court found that, right? And these aren't just, you're not in private practice, right? You are supposed to be, in theory, public servants. And so I think, to transparency's point here, you shouldn't expect that your name won't come out at some point because you're doing something that's serious, right? You have a ton of power and a lot of discretion. And so I think that there is this notch on the belt thing, and I do think prosecutors want to investigate. I think I sort of asked a red herring question there about whether or not I thought prosecutors could regulate themselves. And I noticed that you mentioned Eric, and yes, he did. He wrote a report about the first 40 exonerations that the CIU undertook. But he didn't name names. And that's a balance as well. I do think that full transparency would have been naming names, but some of those people were in his office still. Some of them were, I think I mean, one of them was the CIU chief at the time, the man who was charged with investigating and deciding which convictions should be vacated. I think there are thorny issues there within prosecutors' offices about who they think is getting looked at and who's not. But I think that culture-wise, the culture is broken. And I think that certain prosecutors have done more than others to try to grapple with that, but I do think that it's hard. And I think this is why the CPC is necessary, because you need some independent outside body to be able to say, we're going to name the names or we're going to say the thing. And so then you can provide cover for the DA, but the DA then can maybe do the right thing without having to be put in that difficult position. But that's just my 2 cents, having thought a lot about prosecution culture.
The only thing I would add to that is right on point is that, we can't underestimate the extent to which society can pressure some of these, we as communities can pressure these offices, right? Queens is such an interesting example of that in terms of that last election, and, Tiffany Caban, who was here just last year, having that conversation. And, what are we demanding from our elected officials? And I think that does have some, not all, but something to do with the culture that they create in the offices as they are. The best quote I can think of is that when it comes to prosecutors, you're never going to get called into your supervisor's office for a conviction. You get called in for dismissing a case, right? And so that, until we change what the value system for us and for prosecutors is, I think we're going to continue to have a culture that gets us into the same place.
Yeah, so the vast majority, it seems like, of prosecutorial misconduct was blessed at some point by a judge, either at the trial level or appellate level. And I'm just curious whether either of your organization, and it seems to me like one of the best ways to address prosecutorial misconduct is to have judges that care more about a defendant's due process rights than the reputation of the prosecutors and the prosecutors' offices. And I'm just wondering if either of your organizations has any plans to hold accountable the judges that facilitate prosecutorial misconduct.
That's, I have not, well, I should say that there's a Commission on Judicial Conduct. And so if anyone believes that a judge has done something that would qualify, if anyone has an allegation of misconduct by a judge, they should bring that to the CJC. They are, in fact, the only body that can review allegations of judicial misconduct and sanction them. They are, unlike the CPC, they are fully protected. They are written into the New York State Constitution. And so if there's any concern that a judge is not following their oath to uphold the New York State and federal constitutions, then those concerns, I think, should be brought to the CJC. They are the appropriate body for that.
Yeah, and I would say for this project, no, that hasn't been a part of the plan. Although I do think the question of, in all of these decisions that we were working off of, a judge could have and should have perhaps referred that to the grievance committee at that time, right? And when you look at Supreme Court case law related to immunity, it contemplates that that's, there's already a system for this. Judges will surely, refer it to grievance committees. And so I think there is, training, reinforcement opportunity to suggest that judges should be doing this a little bit more. But that's just one aspect that comes to mind.
I think we have time for one more question. Sorry. Too many hands all at once.
Thank you. This question's more so directed to Professor Smith-Fitzgerald, but feel free to answer. How do your thoughts on carceral abolition influence your work on prosecutorial misconduct?
It's a good question. That's something I have to sort of moderate when I'm coming into some of these spaces in a way, because at the end of the day, I question really the whole enterprise, right? And when we talk about the fact that the way prosecution is designed is overly punitive, Part of the reason perhaps prosecutors don't want to be held to account is because they can only think of one mode that is a punitive mode, right? So I guess I look at it more as part of the incremental steps to dismantling the whole entire thing, right? And so the more that we get information, the more we call into question the violations that are happening, is the more idea that we have about what is going on that happens in a very secretive way right now. So I'm not in it to make prosecution better or stronger. I'm really wanting to get that transparency so that we can move closer to some other alternative.
Great. Well, thank you, Susan and Nicole, again for coming. Thank you all.